With the few minutes that I have left, I would like to just state that while the court is allowed to look at the standing issue, as I said a moment ago, de novo, I believe that there are sufficient findings in the record to show that Mr. Galden proved by a preponderance of the evidence that Marvin Ramsey was commissioned to get B-roll footage for him, and that it is up to Control Galden as to when that is to be released, and that should be sufficient to establish a privacy interest in the footage that is both subjective to Mr. Galden, objective in terms of societal expectations, and that the district court's ruling should be affirmed. I don't like to speak just for the sake of speaking. I know I have 2 minutes left on my time. If there's any other questions, I would be glad to entertain them.
Nope, very interesting issue, but I think we've plumbed it.
Thank you very much. Appreciate it. Congratulations, Judge
Thank
Douglas.
All right, Mr. Yablon.
Thank you, Your Honor. I'd like to focus on one particular point that my friend kept coming back to, and that was that the district court found that there was a relationship between Galden and Ramsey. And I think that's right, but that's not enough. The mere fact of that employment relationship doesn't speak to whether Galden reasonably expected the information to remain private or took precautions to keep it private. And I think this case is very similar to the case Judge Jones referenced, Rawlings, that involved a defendant who stashed drugs in a friend's purse, even though he claimed a property interest in the drugs. There was no reasonable expectation of privacy there. I think another case along those lines is Frick, which involved documents related to a joint business venture that were kept in the business partner's briefcase. And again, despite this agency relationship, despite the fact that the documents, had some bearing on the defendant, the court held that there was no reasonable expectation of privacy. So, Judge Willett, I think your intuition about behind-the-scenes footage ending up in documentaries is the right one here. I think generally an actor lacks a reasonable expectation of privacy in video footage that's filmed, whether that is behind-the-scenes footage or not. But the point I would emphasize here is that even if that intuition doesn't seem ironclad, Galden bore the burden to establish a reasonable expectation of privacy in this case. And the district court made no findings about the specific terms of Galden's relationship with Ramsey, and there wasn't evidence about that either. The evidence that was presented related solely to Atlantic Records' relationship with Ramsey, whether Atlantic Records could insist, with Galden, whether Atlantic Records could insist that he turn over particular footage, and there were no findings and no evidence presented about whether Ramsey was obligated to keep this footage closely held or could use it for other purposes or had to take certain precautions when maintaining it. Finally, I would just like to allay concerns about harder examples. I think the wedding photographer example is a little bit harder because people have different intuitions, despite the fact that the wedding photographer typically retains the property interest in the footage, about whether nonetheless, that because it is very personal footage, someone should have a reasonable expectation of privacy in. And I don't think that's the sort of argument that Galden is making here. And specifically, I'd point to page 19 of his brief, where he says that this footage he would lack a reasonable expectation of privacy in if it were filmed by anyone other than his agent or contract employee, is the term that he uses. And so I think his argument really does hinge on this agency relationship. I think the district court looked at this pretty much the same way, saying that the question it was setting out to answer was the abstract question of whether someone had a reasonable expectation of privacy in video recorded by their cameraman, and then the answer that it gave to that question was a very legally reasoned answer focusing on copyright principles, to basically say that that agency relationship by its own creates a reasonable expectation of privacy. And I don't think that can be squared with this court's precedent and with the Supreme Court's precedent. We go through these cases in our brief on page 19 and then in the reply on page 2. In case after case, this court has held that this sort of a principal agency relationship even if some sort of document or work is produced in the course of that relationship, is not enough to support a reasonable expectation of privacy. So given the public nature of this footage, the fact that it was possessed by a third party, that it was filmed for promotional purposes, and the lack of any evidentiary showing as to terms that would require it to be kept private, the district court suppression order should be reversed.
All right, thank you. We have your argument. And as I said, we only had one case today, so we stand in recess.